live. And so if you want to ask a question, for those of you guys who are showing up live here today, two ways that you can do that. Look at your control panel in that Q&A box. Go ahead and ask your questions. And then after we break from part one, our president, Darren Osborne, is going to read your questions out to us live, and we'll take those one at a time. You can also use that little raise your hand icon in your control panel if you want to ask your question live, and we can unmute your mic so you can do that. And if you're looking to catch up with us outside of this session, I suggest you go and join Govology Nation. That's our private LinkedIn community. And you can get there by going to www.govology.com/nation. And you can also find the recordings on our YouTube channel. We've got a redirect link that's easy to get there. If you just go to govology.com/YouTube, that'll jump you over into our YouTube channel. I suggest that you subscribe if you want to get updates on other topics that we're going to be posting on the show. And then finally, we also have a specific page for the GovCon Roundup live show, and that's govology.com/roundup. And if you go there, you can see our schedule of events, as well as to sign up for any live shows that you might want to join us on in the future. We're going to keep these free, so they're affordable to everybody, and we hope to see you there on those future shows. So with that, that concludes our housekeeping session, and let's jump right into today's show. And it's a pleasure to welcome my co-host, federal regulations expert and FAR whisperer, the one and only Stephen Coprince. Welcome, Stephen.
Hey, thank you, Carol. I'm excited to be here and to have this chance to have just a conversation. Usually when I'm with you, I'm sitting there with a slide deck and kind of presenting in a formal manner. So then that's fun too. But it's also nice to just have a chance just to have back and forth and have a discussion about what's happening in federal procurement, starting with our first edition today of this GovCon Roundup Live.
Yeah, well, thank you for taking some time out of your busy retirement schedule to do this show with us. We're tremendously grateful to you. And for those of you guys who don't know Stephen, he spent his career as one of the top GovCon attorneys that was focused on small business matters. And before he and I started doing some things together, probably back in 2012, I followed Stephen for a long time to keep myself up to speed with everything. And I'm also glad to see he's continuing to write articles on his GovCon Roundup newsletter, which is why I wanted to create this show with him, because as I would read those, I was like, man, I got some good questions I want to ask Stephen, And so I thought this would be a great forum to ask those questions, and also to give you guys an opportunity to ask those questions as well. So again, thank you, Stephen, for joining us. And let's just go ahead and jump right into today's show, which is going to be based around an article that you wrote on LinkedIn titled "The Pending FAR Overhaul, Some Initial Answers." And that was mainly focused on your read of the executive order titled "Restoring Common Sense to the federal procurement." Not sure if that's possible, but that's the title of that particular executive order. And that was published on whitehouse.gov website on April 15th. And then you released this article on April 16th saying that this is going to be the most significant change to federal procurement regulations in decades. So the first thing is, for those who might not have had the liberty of reading your article yet, or the executive order, can you give us a little bit of a recap about what that was and what does that mean, essentially in a nutshell, for federal contractors? And then since you wrote that article, are there any other things that you've seen since then that might be some updates that you want to share with our community today?
Yeah, absolutely. So, and thank you for that kind introduction, Carol. I always prefer when you introduce me because you can say he's a top attorney. I can't say that stuff about myself. I mean, come on now. So I prefer when you do the superlatives for me. That way, I don't come across as being, like I got a big head or something. But thank you for that, and thank you everyone for attending today. So yeah, it's been now about 2 months since I wrote that article. There's nothing in it that is wrong, but there have been some developments since. So let's talk a little bit about this for those of you who, I don't know, have businesses to run and aren't sitting there, reading the federal acquisition.gov website every day to see what's happening in terms of this FAR overhaul, what's now being called, it wasn't at the time in the executive order, but what's now being called by the administration the revolutionary FAR overhaul. And because everything in government contracting has an acronym, it's RFO. And so you hear it called FAR 2.0 or you hear it called RFO. It's the same thing. It's this process of overhauling the FAR. So yeah, the article was really, this was the White House published this executive order on April 15th, tax day, with the confirming rumors that those of us who keep our ear to the ground in the procurement community had been hearing for some weeks, that there's going to be an initiative by the administration to overhaul the FAR, to simplify it, to bring it back to its statutory roots. I think the is language similar to what the executive order says. It's not maybe a direct quote there. But April 15th, this executive order came out. It was called Restoring Common Sense to Federal Procurement. And what it does is it directs the Office of Federal Procurement Policy, working with the FAR Council, to dramatically overhaul the FAR. And so, my article then took a look at kind of the key things that the executive order said and what that means moving forward for the procurement community. So first things first, why are we doing this? Why are we overhauling the FAR? Well, according to the executive order, and this is a direct quote, conducting business with the federal government is often prohibitively inefficient and costly. There are probably not many people who would disagree that sometimes takes place. That sometimes is the case. The executive order points out that the current FAR is now more than 2,000 pages in its print form, and it's grown and grown and grown over the years. Though, when I started my career, my law firm every year bought us the print version of the FAR, and even back then, you could probably get pretty buff by just weightlifting those things if you wanted to, because they're thick. It's a lot, and it was like 8-point font or something, and it's still big, thick. So there's a lot of regulations. They're saying, look, this has gone too far. It's swollen. It's unnecessary bureaucracy. Excuse me. And then in the administration's eyes, the current form of the FAR, it's just too much. It's a barrier to good procurement rather than a rule book for good procurement. That it in its current form prohibits or it discourages businesses from entering the market in the first place because they take a look at that rule book and like, ooh, not for me, and can result in ticky-tack violations of rules, things that are discouraging for contractors to maintain themselves in the market. So the administration says we're going to do this. This sort of sounds like the type of process that maybe is going to take decades to complete, because those of you who are familiar with the FAR Council and how it adopts changes to the FAR know that oftentimes that takes a long, long time. I mean, just taking one example, a few years ago, the SBA, Small Business Administration, overhauled its rules on limitations on subcontracting and said we're gonna do a new formula for limitations on subcontracting. The FAR Council then had the job of essentially copying that into the FAR, FAR 52-219-14. That's the clause for limitation on subcontracting in the FAR. That took 5 years. It took them 5 years to get that clause. The SBA had already written the rule. They just really needed to copy it in the FAR. It took 5 years. So you might say, well, this is going to take a long, long time if we're going to overhaul the whole FAR. But the executive order says, it says 180 days. That's what you have, FAR Council and OFPP. You have 180 days to make this happen. That, by my count, that's mid-October. It's about October 13th of this year that the process is supposed to be complete. So then the major question is, okay, we know who's doing this. It's OFPP with the FAR Council. We know the timeline that it's supposed to be done, which is 180 days from the executive order, which is on April 15th. So what is going to be in and out of the new FAR? Well, the executive order says that the overhaul of the FAR should contain, and this is a quote again, only provisions that are required by statute or are otherwise necessary to support simplicity and usability, strengthen the efficacy of the procurement system, or protect national or economic or national security interests. So that's what it says. It says, look, there are essentially we're going to categorize what's in the FAR under three categories. One that is going to stay, and that's those things that statute requires. Statute, of course, if you remember back to your Bill on the Hill days, all that stuff. That those are the laws that Congress actually passes, and so it's a bill that's been passed by both houses of Congress, House and Senate, signed into law by the president in most cases, or overrode a president's veto or whatever. But we're not going to go down that road. So that's statute. It's a U.S. code, USC, U.S. code. Those are statutory commands, and an executive order cannot overturn statute. And so the executive orders are powerful. The president has a lot of authority to direct the executive branch, but the president cannot, by executive order, overturn or create a rule that conflicts with a statutory command. And so clearly, this executive order says, look, if statute requires that it be in the FAR, it's going to stay in the FAR. The second category of things that this executive order is looking at are going to be things that could stay in and could go out, and those are things that the FAR Council in its delegated authority has implemented. And so by that I mean Congress is sometimes very specific about what it wants. It says, "Hey, FAR Council, write a provision saying that under the simplified acquisition threshold, we're going to apply this rule of two." And we'll talk a little bit more of rule two in a bit. And then the FAR Council does that, writes exactly what Congress said and puts it in the FAR. Sometimes Congress is much more vague. It says, FAR Council, we want you to adopt policies that promote the opportunity for small business to compete in the government marketplace. And then the FAR Council goes with the SBA in this case, probably because it's a small business issue, and creates a policy. Those are things that we don't know if they're going to stay or going to go, because those are not specific statutory commands. Those are things that the FAR Council has done because it was implementing some of this broader policy goal that Congress created, but it's not required to be in the FAR. So that's where we say it's not. It may go, it may stay. And then the third category of things that are in the FAR are items that are in there because of executive orders, because the president, either current President Trump or a previous president, has issued an executive order saying, put this in the FAR, essentially. And those things are going to be, the president has authority to repeal any executive order that he issues or that any of his predecessors have issued. And so those things are going to stay or go depending on what this administration thinks. If it's based on a previous executive order, president can, with a stroke of a pen, repeal that. Exact opposite of the statute, right? And so that's just in the discretion of the executive as to whether he wants to keep or repeal the items that are in the FAR due to executive orders. So that's really what we're looking at here. One final piece of the puzzle is the executive order does address FAR supplements. And so those of you who are experienced contractors, I'm sure you've seen, DFARS, Defense Federal Acquisition Regulation Supplement. You've maybe seen the VAR, that's the VA version. Most, if not all, of the major procuring agencies have supplements that add on to the FAR. So you've got your 2,000 pages, right? Then you've got some supplement on top of it that deals with agency-specific procurement policies and rules. What happens to those FAR supplements? Those are also supposed to be part of this process. And so the executive order says that each procuring agency that has a FAR supplement is supposed to appoint a representative to meet with OFPP and the FAR Council and work through this process essentially hand in hand, so that the FAR supplements go through the same process as the FAR in terms of being revised and in terms of kind of trying to drill down to those statutory roots and say we're keeping that, and then addressing the rest of it in a, is this really important to have in the FAR type question. So that's what the executive order says. And so I'm going to pause there, and then, for your questions and comments, Carol, and then we can talk about kind of where the process has gone in the first 2 months following the executive order.
Yeah, we're going to circle back to that question because been some executive orders that have already been revoked. Those have already created impact. And for those of you guys who haven't been paying attention to them, we're going to talk a little bit about that and talk about just one specific example and also why it's important to really stay abreast of these changes. So before we close, we'll talk about that. But outside of that, Stephen, like, what in your opinion, when you're looking at like, what are these like non-statutory provisions that, if removed, or maybe that you're hearing being discussed, if they were removed, would have the most significant adverse impact on small businesses and how?
Yeah, and so there's a biggie out there, and I sort of alluded to it a little bit, but let's talk about it. And that's your rule of two. And so the rule of two is under FAR Part 19. FAR Part 19.5022-2, I believe, is where you find it. And that is really the primary vehicle by which the government issues contracts or issues solicitations as small business set-asides. And what the rule of two says, and I'm just going to oversimplify it here, essentially, is that when, based on market research, the contracting officer has a reasonable expectation that two or more qualified, capable small businesses are likely to submit offers, then the contracting officer must issue that acquisition as a small business set aside, issue the offers at fair market prices, must issue the acquisition as a small business set aside or some other species of small business contract, such as an 8A set aside, a hub zone set aside, something like that. And so that is the primary vehicle. The rule of two is the primary vehicle that the government uses to promote the congressional policy and statute that small businesses be given a fair opportunity to compete and win a fair proportion of federal contracting dollars. The idea being that when we have multiple small businesses who are likely to bid at fair market prices, they're qualified, capable. Let's restrict that contract for a small business. That rule of two is in large part responsible for the fact that every year the government has, in recent years, has exceeded its 23% goal for small businesses, 23% or more of contracting dollars being awarded to small businesses. And last year was like 27, 28%. I mean, they've been exceeding it by a fair bit in recent years. And we can argue about the goaling and whether the numbers are accurate and all this sort of stuff. That's a totally different question. But bottom line is the rule of two is pushing billions and billions of dollars toward small businesses. The thing about the rule of two is it's only in statute below the simplified acquisition threshold. And so the simplified acquisition threshold, 250,000 for most acquisitions. What 15 USC says, 15 USC is the part of the federal statute that discusses SBA matters, small business matters. So the statute says below the simplified acquisition threshold, or actually between the micro purchase and the simplified acquisition thresholds, the rule of two is statutory. It's mandatory. The RFO process cannot remove the rule of two because it falls into that first bucket I talked about, where if it's in statute, it's a specific statutory command. It stays in because the FAR Council, OFPP, and the president altogether don't have the authority to overturn statute. However, above the simplified acquisition threshold, which the standard threshold is 250,000, but there are exceptions to that where it's higher. But we'll say 250,000, is the standard threshold. The rule of two is not statutory. It's the FAR Council in its discretion. This has been for decades now, has been on the books. In its discretion, decided to write a rule that's very similar to the statutory command for between the micro purchase and simplified acquisition thresholds in order to promote the broad congressional policy of fair proportion of contract dollars going to small businesses, fair number of contracts opportunities being offered to small businesses. And so above the simplified acquisition threshold, that rule of two falls in the category of we don't know what's going to happen to it. And if that goes away, and there's been rumblings that I've heard, this is just rumors. Remember, I keep my ear to the ground on this stuff. Rumors that it could, in fact, go away and be turned into, instead of a requirement to do this rule of two, a sort of unenforceable guideline. a buying guide sort of thing, and an unenforceable guide. That's just a rumor that I've heard, and I can't tell you whether that's true, not true. It's rumors, right? And so unfounded, rumors perhaps. But that's what I've heard is that there's a risk that this rule of two could go away, and that is true. That there is nothing in the statute that mandates that this stay in the farm. That could go away, and maybe it just becomes some sort of contracting officer. If you feel like doing a small business outside, you can, but there's no legal requirement to do it. And for me as a small business advocate, because I spent my career working for small businesses for the most part. I have some clients who are large too, and love you guys too, you large businesses, and other clients of mine who started small and grew large. But I would guess 95% of my clients, at least when we first started working together, were small. And I've always been a very strong advocate of the small business programs. I think that our system is designed to do many things, and one of them is to promote a broad industrial base and brings businesses from all walks of life in as federal contractors, and that means small businesses, not some monopoly or oligarchy system where it's only a few large businesses that are winning contracts. So this is could be a major blow for small businesses if this rule of two goes away. I mean, this is the government's primary tool for getting that 23% and more to small businesses. There are other tools out there, but without the rule of two, I mean, I would be concerned that small business contracting could fall off the cliff in a pretty big way. And so who knows what will happen at this point as we sit here in mid-June. But that is the one that keeps me up at night, worrying that is not it's not safe. That it could stay, it could go, it could be watered down. All sorts of things could happen to the rule of two with this process.
Yeah, I mean, the fact is that a lot of those IDIQ type contracts, the 5-year contracting vehicles where they push a lot of work through, which would ordinarily fall within that rule of two statutory simplified acquisition threshold. If the actual ADIQ is not put out as a small business set aside, what happens then? Like, is nothing inside of that subject to the rule of two within the IDIQ?
Yeah, and then there are court cases about rule two applying to orders, but if the rule two just simply doesn't exist,
Yeah,
then it doesn't matter whether it applies to the IDQ level or the order level or both because it's not there. It's just maybe
yeah,
if we feel like doing a set aside, we will, and some contracting officers will, but
yeah,
others will say, look, like, and this is not fair, I think, to small businesses say, small businesses, that's risky. I'm going to go with brand name large business because if they fail, I'm not going to get in trouble. It's like that old adage from
hmm,
back when IBM was the big player in the field. Like nobody ever got fired for buying IBM. That was the slogan back in the 80s or 90s. To say whether they're good or not, you're not going to get in trouble if you go that route. And I do worry that some contracting officers, and this is not to
uh,
pick on contracting officers, but their ultimate goal is to accomplish a task. And this is not to pick on small businesses because I know full well that many of them are not only capable of accomplishing those tasks, but in many cases are capable of doing it better than the largest. But the large business is safe. It's a brand name. It's safe. The contracting officer is not going to, it's not going to appear like there's a risk when you hire a large business known household name to do your task. And so I would hardly blame somebody who says, I'm just gonna go the safe route and go with that, with the 2025 equivalent of IBM because nobody ever got fired for buying, whatever company that is. So that's
yeah,
the sort of thing that Rule 2 protects against,
yeah,
that sort of mindset. And it's not now you've got larges and smalls competing, and smalls will win some of those competitions, but they're also going to lose a lot.
yeah,
Or they're just going to be discouraged and say, I don't want to enter the market if I got to bid against Google. Like, why would I do that? Like, forget
right,
that.
yeah. So if you were sitting on the FAR Council, or perhaps if there were some people from the FAR Council watching this show live or on demand later, if there's any specific provisions that, if removed, could actually, reduce barriers and maybe help small businesses, do you have any specifics in mind?
Yeah, I mean that's a good question, and I can't say that I have specific ones in mind right now. I do think that the process has it's as a whole is a positive in terms of bringing more entrants to the market. I mean, I do think that the notion that we want to not only reduce the number of regulations and reduce the size of the rule book, but also write the rules in plainer language, which is something else the executive order has asked for that the RFO process is designed to do. I do think that's helpful. You know, that some of these barriers that are in there are potentially statutory in nature, is, you know, in terms of qualifying and all these sorts of things. Um, but I think that the mindset among a lot of the folks in industry, and it's not necessarily wrong, is that government contracting is overregulated, that it's really hard to get into the field because there's so many rules you have to follow, and the rule book is so long that nobody could ever learn it all. And when it, you know, when you see a FAR rule, you can't understand what it means half the time because it's written in legalese. And there's some truth to that. I mean, that's an overstatement of the truth, I think, because the whole FAR doesn't apply to any contractor. A lot of it's just internal rules for the government, or it applies to, you know, you're bidding, negotiate procurements. So FAR Part 14, it's a sealed bid, doesn't apply to you. So that's never been quite maybe as bad as folks say, but there's no question that is true. That it can look very scary to see this laundry list of FAR clauses just incorporated by reference in a contract, and you're supposed to what, look up, you know, 50 different clauses and understand what all of them mean and comply with all. And the answer is yeah, they're all part of your contract. So I do think this process has value in that. I do think that some of the stuff though that that is just discouraging contractors right now, like CMMC, for example. Like that's not going away. I mean, that's,
Hmm.
you know, that's going to stay, and that's not. I'm not saying it should go away. You know, or, you know, these new questions about they're strengthening the rules on FOCI, foreign ownership, control, and influence. I'm not saying that should go away, but that's going to stay. Some of these provisions about Buy American, they're actually strengthening those provisions. Those aren't going away. Those are going to stay. And so I do think that some of the things that contractors find challenging when selling to the government, you know, this process is going to potentially reduce that, some of that, but it's not, certainly not going to eliminate it, because a lot of those have statutory roots, and they're not going away unless Congress changes its mind and says, sure, you can sell us, you know, Chinese products anytime you
Hmm.
want with no, and that's probably not going to happen.
Yeah. It's interesting. So, uh, Stephen, what if anything, like if small businesses are concerned about this, if they don't want to see the rule of two go away, or perhaps maybe some of those Apex Accelerator folks that are out there probably watching this now, or maybe even some of the SBDCs that support some of their clients in government contracting, or other advocates, what can be done, if anything, to maybe like influence or make the case on what should stay or what should go? And it sounds like the FAR Council kind of has that discretion, right?
Yeah, for now, you know, they do, and
Can
so
you
you
send
can
an
make
email
your,
to the FAR Council?
you can actually, yeah. I mean, if you go to the, you know, I don't have the email in front of me. Maybe we can send this out to folks later. But if you go to the Revolutionary Fire Overhaul, if you just, you know, put that into Google or your favorite search engine and pull up that page, it's part of the acquisition.gov website, and there is an email address where they say you basically make your opinions known, and so there's no harm in doing that. Really, how much that will be considered as they move forward, I don't know, but certainly putting your 2 cents in and saying, you know, the rule of two is how I get my business. I bid on small business set asides. If you take this away, you're going to kill my business. If that's true, don't lie and say that's true if it's not. But if that's true, then, you know, I'm not going to sell the government anymore if I have to compete against Microsoft, because no, thank you. You know, I'm okay. You know, tell them that. There is a bill that's introduced in the it was introduced in the House of Representatives as well. The House of Representatives bill was introduced. I think it was just you know, gosh, when did that? I don't remember the day it was introduced, but anyway, it's in there. It's called the Protecting Small Business Competitions Act of 2025. Protecting Small Business Competitions Act of 2025. It was introduced by Representative Velasquez of New York. It's HR 2804. If you want to know the number of that, again, you know, I'm not lobbying. I'm not lobbyist. I'm not up there lobbying on Capitol Hill. But what that bill would do is it would it would codify the rule of two above the simplified acquisition threshold. It would put it in the statute. It would solve the problem. It would take it from the bucket, the second bucket I talked about, which is could stay, could go. Depends on how important we think this is for federal procurement policy, and move it into the first bucket, which is must stay because it's a congressional command. And so that's what that bill would do. I personally support the bill. Again, this is my personal opinion. It doesn't reflect the opinion of Gavology or any of the other entities I work for, because I support small business, and I think this is important to safeguard the rule of two, which is really important for small businesses. So that bill was introduced. It is now in front of the House Committee on Small Business, and so if you're someone who would support that bill, take a look at it. Reach out to your member of Congress. Let them know that you support this bill, especially if your member of Congress is on that House Committee on Small Business, and you can go to the committee's website and see who's on that committee, because that's the committee that would ultimately decide whether that bill moves forward to the full House floor. So we'll see. That could be a passed as a standalone bill. It could be included in a National Defense Authorization Act or some other omnibus bill. That would be the gold standard to protect the rule of two, would be to put it in statute, because then it's safe unless Congress decides to repeal it. So we'll see if that moves forward. And then finally, the federal the FAR Council has this discretion, of course, as they're doing this. You can email them and say, this is what I think. Ultimately, though, there will be a formal rulemaking process on this through the Administrative Procedure Act. And so right now, the FAR Council is going through this RFO process by producing revised versions of the FAR parts. They're part by part. They're doing these revisions, and they're posting them on their website and encouraging agencies to adopt them temporarily as deviations. And so that's what they're doing. But ultimately, to make this permanent, to replace the current FAR with the RFO FAR, they have to go through a formal rulemaking process, defined again by the Administrative Procedure Act. And what that's going to involve is the FAR Council is going to have to issue a proposed rule that says we want to replace the FAR with the RFO FAR. And at that point, the public has to have the opportunity to weigh in with comments on that, formal comments on that rule. So that would be ultimately another opportunity to weigh in. The problem is that if this rule of two goes away in RFO Part 19, by the time we get around to commenting on the draft, it will likely have been out of the FAR, deviation wise, at least for some period of time, months, maybe years. So it's not a perfect answer, but it is ultimately something you'll have the opportunity to do. All of us will have the opportunity to do, to comment on the Administrative Procedure Act process. But my two items that I would leave folks with are write to the FAR Council and the OFPP through that email address on the website, and consider supporting HR 2804, which is that Protecting Small Business Competitions Act of 2025.
Awesome, man. That's a great tip. And I hope that all of you do that, man, and really get your voice heard out there. So thank you for that tip, Stephen. I want to kind of wrap up so we can get to the part two of this with our Q&A. But I really want to quickly talk about something that you mentioned earlier with executive orders, because these are things that are made by the president. They're not statutory. And we've already seen some executive orders from the Biden administration revoked. One has been related to small disadvantaged business. Historically, the goal has always been 5%. Then that was set, at 15%. Now it's been revoked back to 5%. The other big one that I think is really impactful in terms of price, when people are pricing wage rates in certain contracts, is the one about the federal minimum wages. So, President Biden had made an executive order to set the federal minimum wage at like $15 an hour, which I think now adjusted for inflation would be like over $17 an hour. That was revoked. So based upon, you and I were talking about this before the show, but based upon where is it now, right? So I think you kind of got to go back to what was the last executive order, which was posted by President Obama, which was set, I think, about 10 dollars something an hour, and adjusted for wages, inflation, like 13 something an hour, I think now. So it's very confusing, I think, to a lot of folks. So what is your take on some of this, really quickly? And are there any other ones that you've seen that kind of have been revoked that really could significantly impact the way a contractor is doing a proposal or pricing?
Yeah, and so you're absolutely right. I mean, at the start of his term, the president, revoked a whole bunch of executive orders that his predecessor issued, as well as some executive orders that were issued by previous presidents, many in the Biden administration, but from previous administrations as well. And so, yeah, I think there are just three. Let's quickly highlight that you spoke about two of them, and I'll highlight just one more. And this is, 2025. This is why 2025 is going to be one of the most impactful years for federal procurement regulations in the history of federal procurement, because we not only have this RFO process going on, but we have, also executive orders that are, touching this as well. And so then we had Doge, and I mean, there's just all a very impactful year for better or for worse. And some folks are going to come out ahead behind whatever. That's not a positive or negative comment. Just to say there's a lot going on in 2025 in federal contracting. So yeah, there were a number of executive orders that were repealed. I'll highlight just the three quickly. One was, as you mentioned, the goal for small disadvantaged businesses. That goal is set by statute at 5%. Small disadvantaged businesses is a category that includes 8As, which are essentially certified small disadvantaged businesses, and it includes folks who check the box in SAM to self-certify as small disadvantaged businesses. By the way, my opinion is you probably shouldn't do that. You probably shouldn't check self-certify as a small disadvantaged business on SAM. Different question, but there's not much advantage to it because there's no set-aside contracts or sole source contracts for self-certified SCBs. Anyway, we've had different discussions about that one. So the Biden administration took a look at the numbers and said, hey, we've been beating this 10% or this 5% goal for years. We're up around 10, 11%. We want to increase the goal for SDB to 15%. And so that originally was just sort of an internal policy memo. And then President Biden, this is, issued an executive order setting the SDB goal at 15%. And remember, I said a president cannot overturn a statute and say, how did this do this? If the statute set the goal as 5%, how could President Biden increase it to 15? That's because the statute in question puts 5% as a floor, but allows the president to unilaterally increase any goal. And so the President Biden, to my knowledge, is the only president to ever have done this with any of the goals, but by executive order, using the power delegated by statute, increased the SDB goal to 15%. It was a staggered thing, like 11% one year, 12%. It's supposed to be 15% this year, 2025. That executive order was repealed. Now that freaks some folks out, and they said, does that mean that um, that there's no goal for SDBs anymore? No, that essentially just means that the executive order was that increase, that 10% increase between 5 and 15, means the goal resets to its statutory floor of 5%. And SBA has confirmed that. They issued, not long after this executive order, a goaling sheet essentially saying, yep, the goal is 5% again per statute. So that's one. You highlighted the second one. I think an important one to keep an eye on, as well as this federal contractor minimum wage. And the federal contractor minimum wage is a minimum wage for folks who are working on federal government contracts. And this is different than our prevailing wage statutes like Davis-Bacon Act, Service Contract Act, but essentially saying it's a number that's above the national minimum wage that we as a government have wanted our folks who are working on our contracts to be making some minimum wage that's above the national minimum wage. That's been done by executive order. And so President Obama had issued an executive order during his term. I think it was maybe even in his first term, that established a minimum wage. That I believe he was the first one to do that as a president, to establish a higher minimum wage for federal contractors, employees working on contracts than the national minimum wage. President Biden, as Carol you mentioned, then came in and issued an executive order with a higher number on it. Both were being adjusted for inflation. As I understand it, then President Trump repealed President Biden's executive order, but did not repeal President Obama's executive order. And so what that means is that the Biden higher number disappears, and that the minimum wage doesn't revert to the federal national minimum wage, but instead reverts to the Obama minimum wage adjusted for inflation. And so that's where we are, which I think, as you mentioned, Carol, as I understand it, would be somewhere around 1330 right now. The added wrinkle to this is that, these executive orders, the Obama executive order and the Biden executive order, were put into regulation by the Department of Labor, and as far as I know, the Department of Labor has not yet implemented the executive order by repealing in its regulations the the Biden number, right? And so we've got this, if I'm correct about this, they haven't done that yet. We've got this odd situation where you've got a minimum wage that the DOL regulations are going to require, but there's no legal underpinning for it anymore because the legal underpinning was a executive order, and maybe your contract bakes in one number or the other. I don't know. This is a situation where if I were in that boat, because this is not a legal advice show, I would call my attorney and say, here's where I am. I need to know if, what number applies to me right now on this contract, and let them walk through figuring out whether you're under the old Biden number, whether you're under the Obama number, what happens to those employees under that contract that might be affected by this. And then the third thing I'd finally mention is that, and you may have seen this, it's almost a point of interest rather than something that maybe is going to have a dramatic impact at this point, is that the President Trump repealed the executive order that inserted an equal opportunity clause into the FAR. And so the FAR equal opportunity clause had been there for 50 years, 60. I think it was from President Johnson. It had been there forever through administrations of both parties, including the first Trump administration. And it's the clause that required these equal opportunity matters to be contractors to adopt certain equal opportunity requirements, et cetera, et cetera. That has been repealed. And so what does that mean? Does that mean you can just randomly discriminate however you want? No, 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 no. There's still plenty of non-discrimination laws out there, like Title VII, for example. There are statutory state, non-discrimination laws. So I say is almost, there are definitely nuances to that, the contract level, but it does not just like give you green light to start being, not that anyone on this webinar would do that, to start discriminating right and left. But it was just kind of a shock to a lot of folks who were, because this clause had been there for so long in federal contracting, to see that disappear. So those are the ones I'd highlight, but they're not the only ones. And in fact, if you're curious, go again to your favorite search engine and search, something like, executive orders repealing, contractor FAR clauses or something along those lines. And there are some articles out there that will walk through some of the other changes that have happened. It's good just to get that kind of higher level view, because most folks who are busy running a business don't have the time to be hunting around on the whitehouse.gov to look at the executive orders and compare it to their contracts and all this. But there are a lot of great folks out there, attorneys and consultants and others, who are keeping a close eye on this stuff. I'm certainly not the only one, and who are writing on LinkedIn or on their law firm blogs or wherever, articles that can give you a high level overview about what's going on. And now more than ever, I think it's important for contractors to educate themselves, and to find folks that they trust and they like, and that write in a way or that speak in a way that it's understandable to them, that cover these sorts of things, so that they can stay up to speed on what's going on, because there's just so much. Stuff's flying at you. But there are people out there who their whole job is to keep on top of this stuff and advise people. And you can call them and pay money for a consultation. That's wonderful too. But you can also find, to start, just a lot of great information out there totally free. And that's a great place to start, as long as the source you're getting it from is someone who's trustworthy and knows what they're talking about.
Awesome. Well, hey, this has been great, Stephen. I want to wrap up here, and we're going to get to some questions from the audience. But just in closing, I've got a couple of announcements that I'd like to make and give you guys a couple of plugs. Obviously, the things that we just talked about, and I've kind of been talking about this for years. It's so important to really stay abreast of these changes, because you can see just how the revocation of one executive order can put you at a significant, disadvantage in some, pricing models if you're, pricing $5 off what other people might be pricing per hour. So that is just kind of one example. So I encourage you to continue to join us every month. We're going to be coming back and talking about more of these topics. I'm sure we're going to be talking about updates as we see them and as they occur. And as Stephen writes that on his GovCon Roundup newsletter on LinkedIn, which you could actually simply Google. If you just do GovCon Roundup newsletter LinkedIn, it'll bring you right to his newsletter. Highly encourage that you guys subscribe to that. Also, another great resources is the smallgovcon.com blog. It's a blog that Stephen started when he was a federal contracting attorney, and it's being continued by the good folks who purchased his law firm, Co-Prince Putroff and McCall, or the KPM, right?
Yeah,
Prince.
KPM, Copeland's Pottruff McCall.
Right.
Yeah, these are not just the folks who purchased my firm. They're former partners of mine and
Yeah.
good friends of mine. They're wonderful human beings, so who know this stuff really well. So they and their colleagues, because they have several other folks working with them, attorneys as well, who focus exclusively on federal government contracts law, and within that, again, the vast majority of their work undoubtedly is still with small businesses, as it was when I was with the firm.
Yeah. And again, for those of you guys who want to join us next month or check out the recording, you can go to govology.com/YouTube. That's going to jump you over to our YouTube page where you can watch the recording. Also, you can go to GovCon or govology.com/roundup. And if you want to join us live for our next show, where you can ask questions in the Q&A afterwards. And with that, I'd like to go ahead and sign off from the first part of our show here today. This wraps up the GovCon Roundup Live episode 1. And thank you again so much, Stephen, for being with us. We're going to be back next month with more insights, updates, and real talk from the front lines of federal contracting. So until next time, stay smart, stay informed, and we'll see you then.
Thank you, everyone.
Yeah, thank you. So what we're going to do now, guys, is we're going to break for questions. And so I'm going to turn it over to Darren Osborne, our president. And I do see we have a few hands raised, and I know that there's probably a number of questions that have come in through the chat. We're going to get through as many of them as we can. We've got about 10 minutes for questions. So we'll try to keep the answers a bit short and to the point. But if we don't get to your question, we'll take a look at those and see if we can get them answered and send you guys back out. For those of you guys who are with us live, hanging out in the Q&A today, see if we can get you an answer. One other resource I wanted to share with you guys that we just developed, currently in beta testing, is we're adding an AI component to our website. So if you go to govology.com/Sammy, SAMMY, we've been training it, but it's still in beta version. So help us test it out. But a lot of these things that if you're trying to understand what's happening, it really provides some good information. We do know that's not even the main ChatGPT model is 100% accurate. So always kind of double check with your experts and your resource partners out there at the Apex accelerators, your GovCon attorneys. But it's just a really good way to kind of go for a quick answer or maybe an update to kind of see how maybe some of these changes are impacting you and maybe what you can do about it in between shows. So anyway, Darren, let's go to the raised hands first and take the live questions.
Yeah, Carol, as I look at this here, we have a raised hand from Matthew Fian. And I am not being given the option to allow Matthew to unmute his microphone.
Okay. Are you able to reclaim host? Or Elena, can you unmute? Yeah, I think we need to get you to reclaim the host there.
Yeah. I'll tell you what I'll do. I'll work on reclaiming the host duties, but in the meantime, I'll give you a question that's in our Q&A box. And the question is, so I presume the public laws we are used to in procurement will stay, the low-hanging fruit, example, debarment, certification, anti-lobbying, DPAS, etc. Is that correct?
Yeah, I mean anything that's in the public law, which is PL, which is essentially what happens is the public law is when the bill gets passed into law, becomes a public law, then it eventually makes its way into the U.S. code. So anything that's in there is going to stay. There may be nuances around the edge as to how that's being implemented in the FAR, but if it's required by any sort of statute, which would be a public law PL or USC, both. I mean, ultimately, it's both. It becomes public law, and then becomes statute. Then yeah, then it will stay there. And so you see a lot of those things are going to be the same. I would also venture to guess that anything, and I haven't done a deep dive on, FAR Part 3 or FAR Part 9, where a lot of these rules are contained yet. There's not an RFO revision out on those yet. But I would venture to guess this is probably not going to be an administration that's going to try to make it easier for folks to get away with fraud and such. That doesn't seem to be their mindset right now. So I would imagine all that sort of stuff is going to stay, the debarment and all that sort of thing.
All right. And Carol, I think the current host may have to designate me as the host as I look at the options here. I don't see the option to reclaim host, but
Okay.
I'll ask the next question in the Q&A
Let me
box.
see something. Let me see if I
We
can.
can get Matthew to put his question in the chat box as well.
I
Too,
think
yeah.
I hit
Darren
Matthew.
already made you host.
Okay, so when
I think Matthew might be on now. Matthew, are you there?
Yep, here. Thanks so much for your
All
time,
right.
guys.
all good.
Awesome.
Yeah, really appreciate it. Wonderful talk. Just a really quick question. Stephen, do you think this is going to be gratuitous for the rulemaking? I expect there's probably going to be litigation, but I haven't seen it used before, but I might see it be used here, which is campaign comments for this rulemaking. And I was curious what your thoughts are on this.
Yeah, what is campaign comments? I don't even know what that means. I'm sorry, you're ahead of me on that one. So.
No, it's fine. The rules prohibit organized campaigning. So instead of having one individual legitimate rulemaking comment, we've got 2,000 on behalf of.
Oh, I see what you're talking about. Yeah. We'll see what comes out. That's a great question. I don't know the answer to that. I think that what you're going to see, if nothing else, is we got 3,095 comments saying don't do that to FAR Part 19, and we're addressing them all with these two paragraphs. I mean that's
right.
that I've seen happen before. Like they just lump the bunch of people oppose this rule. We do this. We did that. So. I would expect you see some of that coming probably as when the rulemaking process gets there. I'm always a little skeptical myself whenever you see something that's done kind of as a interim final rule or whatever the case is, a deviation that they're really going to change a lot of course because of the comments. I haven't seen any studies on that, but I don't know. It's like it seems like you've kind of already made your mind up, but yeah, that would be my guess. Is that either they would say something like, "Hey, if you just want to say yay or nay to the rule, that's fine, but we don't need to hear any more from you on that," or more likely they just lump all those into one and say, like I said, we got thousands of comments saying don't do this, and here's why we are, and here's our here's our explanation. I mean, and I have seen them do, not with thousands, but I've seen them do that with, we got dozens of comments saying we don't support this rule, and here's why here's why we're doing it anyway, or whatever the case is. So that would be my guess. I'd be interested to see, but I don't know when the APA process on this is going to get moving. If it would be right after the October deadline, if they get everything done, or if we're really going to start having that grinding process that these rulemakings can take when they go through that process.
Thanks, Stephen. Thanks, Carol.
Yeah, thank you for coming, and always appreciate your kind words on LinkedIn. So thank you.
Yeah, thank you, Matthew. So we'll go back to Darren with the questions, and really quick before we segue back to the questions, let's see. Shauna Weatherly had posted a good tip saying that each part in the FAR overhaul, as published on the site, has its own link for feedback. So parts are listed at, and she shared a link. So click on each part, and the feedback button for the part is on the right. So Darren, when you get a chance, maybe you could kind of copy and repost that comment from Shauna. Another contracting guru. So, hey, thanks for being here, Shauna.
Yeah, no, thank you, Shauna, for that great tip. And one more tip I would give folks: if you go to that site shows you which FAR parts have already been revised, essentially, so you can see. They just posted one this morning. So I think it was FAR Part 11 that came out this morning, right before I hopped on here. So that process is ongoing. And the question is 180 days. What are they doing now? They're rolling process of getting these FAR parts revised. And so you can read each revised part, and you can then keep track of which ones are coming out and when they're coming out. So this process is moving forward. I would recommend that folks go to that website, and then that'll help them keep on top of what's happening there.
Yeah, and Darren just posted that link there. So thank you,
Oh, and
Darren.
I would
You're
also
welcome.
point out that on that site you can see which agencies have adopted the deviation, because now we're in this interesting world where the FAR may be different depending on what
Yeah.
agency your contract. Like I'm not kidding. Like, is your contract subject to current or old FAR Part 1 or new FAR Part 1? Well, the answer right now is it depends. It literally depends. If you're doing business with the GSA, they've done a deviation. It's new FAR Part 1. If it's DoD, last I checked, they haven't adopted it yet. It's old FAR Part 1. So the question about which FAR applies to which acquisition is which FAR. I mean, it's gonna be an open question as long as we have this deviation process out there, so you can check on there which agencies have adopted the RFO version, and if the agency's not on there, that means they're still using the old version.
All right, we can move on then to the next question in the Q&A box. So the person who posed this says, while the FAR is insanely long, so much of the regulation is to ensure fairness and transparency, ensure taxpayer dollars are spent wisely, and protect the USG interests, U.S. government interests. Many of the clauses are there to make sure companies can't legally take advantage of government procurement while also promoting different goals like supporting small business. Are you concerned that this overhaul is going to remove a lot of those protections and essentially change the fundamental purpose of the FAR?
That's a great question, because that's kind of the balance of the scale, right? Is that the FAR is very, very long. In some cases, it's just overly wordy, or things that are in there that I think most people might have rolled their eyes and say, do we really need that? A few years ago, they repealed, for example, the clause on, every contractor must have a policy against texting while driving. Well, that's a good thing, but do we really need a FAR clause on that? I mean, every benefit to society. Maybe if you're doing a trucking contract or something, we'll put that out there, but just generally. So, there are things that are probably overkill in there, and there are places where the FAR is written in a way that as a lawyer I kind of like, oh, that's too wordy and legalese, so we wanted to go more plain language. But you're absolutely right. I mean, I do, like, I stay up at night worrying that that, for example, the rule of two is going to go away, because that would fundamentally change the landscape of small business. But you're absolutely right in terms of some of the other things that the FAR does, because with the FAR ultimately, and I'm not anti-FAR by any means. I mean, like I said, I make fun of it like anybody else, the weightlifting and all that, but I understand where the drafters are coming from with that, because they're trying to give a rule book to the government that allows them to do business with industry in a way that we hope is fair and transparent, keeping in mind that especially when you're dealing with small business, but even larger business, there's a huge difference in bargaining strength between the U.S. federal government and a business. And so to try to encourage businesses to come in, to sell to the government, to understand they're going to be treated right, that they're going to be treated fairly, that they're not going to lose out on a contract because somebody's brother, plays poker with the contract, all these sorts of things. We want all those things to be in the FAR, so that folks understand that when things go awry, and I post these articles or headlines too about bribery and false claims act and this stuff, but that's the exception. It's not the rule, that those people have violated the process. So yeah, I keep my fingers crossed that we can do this in a way that is going to preserve that intent, and that is ultimately going to encourage contractors to come in, because they're less worried about overregulation. But you're absolutely right that if the revision turns out that it is simpler to read, but it also offers fewer guarantees of transparency, fewer guarantees of fair treatment, that contractors feel like, oh, it makes me uncomfortable to do business with the government now because I can't file a claim the same way. I don't have the same protections if I'm gonna get before I get terminated for default. They're not going to give me a notice or whatever we could talk about there. Cure notice, for those sorts of things that might discourage people from coming in. There are all sorts of provisions in the FAR that are meant to help protect contractors in that relationship, and some of those are statutory and some are not. And so yeah, I think that's a great question. I don't have the answer to it, but like you, I'm waiting to see, and I hope that what comes out is able to find that middle ground between being unduly burdensome in terms of wordiness, in terms of legalese, in terms of imposing obligations that probably are just unnecessary to put it on contractors, but not by the same token, not upsetting that balance toward transparency and fairness, because without that, we're not going to have a system that anyone wants to do business with. So I'll keep my fingers crossed, and I appreciate the question because that's a really good point, and we'll have a lot more information on that in the next 3 or 4 months. So stay tuned.
Yeah, and I know
Oh,
we're at 2:02 right now, and I wanted to ask you, Stephen, do you have a hard stop or do you have a few minutes for overtime?
Yeah, we can go over time for a few minutes. I mean,
We
why
actually
not? We
just
always
have a
like to
few.
talk about
We have a few
procurement.
more questions, and
Sure.
there's one down the pipeline here. But yeah, go ahead, Darren. Let's continue, and I think we could get through all of these questions and then be out of here by 2:15.
all
If that's
right.
all right.
Well, yeah, Stephen, your reference in that previous question and your response to that question to the rule of two is timely because this next question addresses that. And the question comes from Jeff Kuski. And he, of course, is a Gavology
Jeff,
faculty member.
Good old
Great to
Jeff.
have you here. Great
We
to
got a
have you here,
dream
Jeff.
team on this webinar today. This is awesome.
Got the A team.
That's
So
right.
the question is, since the Small Business Act at 15 USC 644G establishes the framework for federal small business goals, would the removal of Rule of Two contravene the congressional intent of the Small Business Act? And if the Rule of Two is removed from the FAR, what processes would remain to help federal agencies meet the small business contracting goals?
Yeah, those are great questions, Jeff. You can always count on Jeff to make you think. So um, this is just my opinion, and I'm just giving my opinion as somebody who knows. I've read exactly what Jeff is talking about. 15 USC 637G, I think, is what we're talking about now. But the goaling parts of the FAR, and so the FAR sets up this framework of, for those who are not quite as up to speed with Jeff on this, of goals. We referred to this in the small disadvantaged business world as well in this talk. For small businesses, the 23% of prime contract dollars to small businesses, and then individual goals for small disadvantaged business, woman-owned small business, SDVOSB, service disabled veteran-owned small business, and hub zone. And so the question then is, if we remove the rule of two, are we essentially undermining that structure? Is there a legal argument maybe to be made that we're undermining that, the ability essentially of agencies to get to the 23%? My opinion is not in and of itself. It probably depends what happens after, what comes after that, like what replaces the rule of two, if anything. Because the statute doesn't mandate a certain way of getting to the goal. It sets out a public policy of, we're going to do, we want small businesses to have a fair opportunity to compete and to receive a fair proportion, just a fair proportion of federal contracting dollars. And then later it sets up these goals, but it doesn't direct a way to get there, other than the small business rule of two under the simplified acquisition threshold, between the micro purchase and simplified acquisition threshold. And then there's some other pieces for 8A and stuff. We're not going to talk about that now. We'll just talk about small business stuff. So if you get rid of the rule two and you put absolutely nothing in the FAR that even allows an optional small business set aside, maybe you're now in a place where you say, look, this contracting officers literally don't have the tools. How are they supposed to get uh, to a 23% number if they have no tools to direct contracts to a small businesses? They have to just put contracts out unrestricted and hope for the best. They can, I guess, then double count awards that are being, awarded to SDVOSBs and 8As and so forth. But there's no tool that's offered even in a discretionary way to to do a small business set aside, then maybe there's an argument that this action contradicts the statute. However, if the rumor is true that I heard, that I've been hearing from a few sources, in that we might remove the rule of two as a mandatory thing and put it into a guideline, like you can, if these things are met, if there are two or more small businesses that are qualified, capable, going to offer a fair market price, that you can, if you want, agency in your discretion, do a small business set aside. That now we're in a different world, because now the agency has a tool to get to the 23%. It's just up to them whether they choose to use it or not. And so that's a different question. And so, people say, well, if they have the tool, it's a discretionary, then they're probably going to get to the 23%. But will they? I mean, they have the tool to do hub zone set asides, and they haven't gotten to the 3% hub zone goal. So I like the mandatory the piece of the rule of two now, but I think that to answer Jeff's question, it may depend on what replaces the rule of two. If it's a discretionary rule of two, that may be one world. If there's no tool at all, maybe there's an argument. Maybe not. That's maybe you still lose that case if you're a small business and try to bring that case. But now you at least have an argument. I think that there's not really that the revision has left the government without a tool to achieve a mandatory goal, because the statute is by mandatory goal, I mean it's not mandatory that they meet the goal, but the goal is in statute. The goal cannot be lower below 23%. By the executive or by anybody else. So great question. We'll see what replaces it, if it's replaced at all. I hope it won't be replaced. I hope maybe that this bill is passed to codify it even, but if not, then we'll see what tool or tools are made available to agencies to enable them to continue to get 23% and above. And if there's no tool that could possibly be said to get you there, then maybe there's an argument that that we went too far. We took away the tools that are necessary to meet that. So great question. I mean, this is Jeff for you. If you guys have not taken any webinars with Jeff, by the way, please look for them on Govology, because he does a great job, and it's always full of wonderful information.
Thanks, Jeff.
All right, so our next question from the audience. Thank you, Carol and Stephen. You guys do great work. With regard to rolling back the 15% goal for small disadvantaged businesses, how will service-disabled veteran-owned small businesses be impacted? As I understand it, SDVOSBs aren't included under DEI initiatives.
Yeah, that's correct. And so we're talking about two different goals, really. So the small disadvantaged business goal, SDB, is for companies that are 8A, which, by the way, a number of SDVOSBs are also SDBs. They're also 8A, or they've self-certified as SDBs because they believe that they meet the criteria to be one. Again, my 2 cents is please don't do that unless you're really, really sure that, number one, you do meet the criteria. Number two, there's some reason for you to self-certify, because I think a lot of folks self-certify as SDB and they don't actually meet the criteria. But that's neither here nor there. So SDVOSB is a different, it's a different certification, service disabled veteran-owned small business. It's a different goal. It was 3% for a number of years, and it was recently increased by Congress maybe 2 years ago now to 5%. And that goal is unaffected. It was statutory floor now is 5%. It was 3%. It went up to 5%. That statutory floor has not been affected. It was not raised by the Biden administration. It cannot and was not lowered by the Trump administration. Now, some SDVOSBs are also 8As. I've actually helped some folks who got their 8A certification based on their service-connected disability. So some folks have both those certifications. So those folks could be impacted in terms of that goal falling. But in terms of the SDVOSB goal itself, that hasn't been impacted. And I would also agree with the comment that that my reading of the various, DEI or anti-DEI initiatives that the administration has taken with, at least as regards with federal contracting, are not intended to impact SDVOSBs. Some of at least one of the executive orders that I saw that was talking about, DEI and federal contracting was very specific to say this doesn't affect veteran-owned contracting preferences. It doesn't affect veteran hiring preferences. We're not trying to impact those things, and I think that's the mindset of the administration is that there's not an intent to target veteran-owned small businesses with any sort of anti-DEI type initiative. So yeah, I would say as an SDVSB, you're still there with your 5% goal. You still have that special preference with the VA, where the VA has the Veterans First. That's a statutory thing too, and that hasn't been impacted. And I would also say that my reading is that this administration and its congressional allies don't have any intention of trying to roll back preferences for SDVOSBs.
All right, and Stephen, that may be the answer to the next question from our audience, which was, what projected changes are coming to SDVOSB set-asides?
Yeah, I mean, right now I don't see any projected changes. Maybe Shauna or someone wants to weigh in on that. There are some ideas floating around out there. So the SDVOSB set-aside regime still is a matter of statute for the VA, and also the allowance for the FAR for there to be SDVOSB set-asides under the FAR. The VA has a higher threshold in that they have the Veterans First policy under their statute and under the VAR, where if there are two or more qualified, capable SDVOSBs, then the VA has to prioritize those versus other categories: 8A, hub zone, woman-owned, and ordinary small businesses. And then in the FAR, the SDVOSB is on parity with the other socioeconomic categories. So I haven't seen any indication that any of that is going away or going to be eliminated or threatened by the administration or by Congress. Maybe there's something out there on that, but I doubt it. I don't think it's good politics right now, or probably at any time, to be seen as anti-veteran. There was an initiative last year that made it pretty far, which I'm very curious to see if it comes back this year. It was not adopted last year, but as part of that National Defense Authorization Act, the NDAA, the annual bill that authorizes, funding for the DoD, which also bakes in a lot of other things into that bill, usually because they can get passed, because most folks are going to vote in favor of authorizing funds for the DoD. It's where you see a lot of the new government contracting congressional policies ultimately are adopted as part of this broader bill. And the House version of the last year's NDAA had a provision that would have established a preference program at the DoD for VOSBs, veteran-owned small businesses that did not have the service-connected certification, but are owned by veterans who served honorably and just don't happen to have a service-connected disability. That would have made DoD the only agency other than VA that would be allowed to do VOSB set-asides and sole sources, because right now VA is the only agency that has the authority to do set-aside competitions or sole source contracts based on VOSB certification. And so there was a bill, and it made it all the way through the House. It was passed by the House of Representatives as part of the NDAA that would have had the DoD would have had the ability to do VOSB set aside and sole source contracts, and the DoD actually would have also had a 5% VOSB goal, which would match the SDVOSB goal of 5%. That actually would have been a more powerful preference probably than the VA ability to do VOSB set asides, because in the VA pecking order, VOSB is below SDVOSB. The House bill would have put VOSB on par with all the other socioeconomic categories. So unfortunately, the House and Senate got together in their conference. The Senate bill didn't include that provision, and for whatever reason, it got left on the cutting room floor. There's no VOSB set-aside program created last year, but it got really pretty far. It got all the way to the House-Senate Conference Committee on the NDAA. So I'm very curious to see if that comes back around this year. Maybe it can get through that final hurdle, because I've worked with a number of folks who are veterans and who have great businesses, and they've served honorably, but they don't have service-connected disability, and they're saying, well, the benefits for SDVOSB versus regular VOSB are so different. They're much in terms of contracting preferences and such. So we'll see. That's the only thing that I know of right now that I'm keeping an eye on in the kind of SDVOSB VOSB world. That doesn't mean there aren't other things that are percolating out there, but if so, I'm not aware of those at the moment.
Awesome. Well, hey, Darren, I think we'll probably have to wrap up here. It's 2:15. I know we still have some questions. and a couple of really good comments that were put in the Q&A here. But what we'll do is we'll pull these down, and we'll kind of get some answers to them, and as well as some of the great comments that were posted in here by Shauna and Jeff. And we'll get those back out to those of you guys who joined us. We got your email address, so keep an eye out for that email. We'll send you the show notes with all the reference links and some of these Q&A answers, as well as the comments. So, but with that, again, Stephen, thank you so much. I'm really excited to continue to follow your LinkedIn version of GovCon Roundup, which is the inspiration for why we're here today. So hopefully we'll see another article this month, so we can talk about it next month.
Please subscribe. We've got 8,800 folks. Last I checked, they were subscribed. And also just feel free to follow me on LinkedIn, because we got these longer form articles on GovCon Roundup, but I also am often just shooting out like short little posts on LinkedIn on something or other that's going on. Like this morning, I just posted, "Hey, FAR Part 11 revision is out," with a link to that, so that folks who want to look at that can see it. Not all these make it into the long form articles, but yeah. So please feel free to follow me there as well. I won't think you're stalking me or anything like that. I like it when people follow me. So please feel free to follow, subscribe, and thank you everyone for joining. I'm thrilled to have this opportunity to just kind of chit chat with you, Carol, about what's going on in federal procurement. So excited for the next editions coming up.
Awesome. Well, we'll get together pretty soon and talk about what we're going to talk about next month.
Sounds like a plan.
And if you guys have any ideas and suggestions, please go and look at Stephen's newsletter. Look at some of the articles that he's discussed in his newsletter. Also, as he mentioned, follow him on LinkedIn. The best way to get to either one is just to Google GovCon Roundup newsletter LinkedIn. You'll find a link directly to his newsletter there, and you can just hit the subscribe button to stay up to date, as well as probably look up Stephen Co-Prints LinkedIn, and you'll probably find his profile pretty easily. So not sure there's a lot of other Stephen Co-Prints out there in federal contracting.
As far as I know, I'm the only one. If you see him find another one, it's probably fake. So
the real Stephen Co-Prints.
Yeah,
I saw your
real,
comment that you're verified now on LinkedIn.
Yeah. I'm not cool enough for people want to impersonate me, so it's gonna be me. It'll be me.
That's funny. All right, man. Hey, thank you so much, Stephen. Darren, thank you for hosting the Q&A. Thank you guys all for showing up and answering the questions, as well as Elena behind the scenes, who's helped us